When is the last time real property was tested? Was it tested last bar?
July 2016.
Oh, yeah, no. Last year.
Did easements come up last bar? Yes, it did. Real property came up last bar. It's okay if you didn't know it. Well, it's really not okay. But, huh? Okay. Let's go through what they test. What do they test on real property? Let's talk about that. Landlord tenant. Landlord tenant. That's a major area. So it's very categorical, and there's literally maybe 7 or 8 different areas that they test. So what are they? You can write them down. I'm going to give you the real areas I want you to know. Landlord tenant. Easements, equitable servitudes, easements, equitable servitudes, and real covenants. For those 3 areas, you literally can memorize the elements of each approach, and that's all you need to know. For those last 3 areas. The different types of deeds. Concurrent estates, so the joint tenancy rules and the tenant in common rules with all of the just kind of rules that associate with each type of tenancy. We'll talk about that. Zoning rules. Make sure you know the zoning rules. The takings clause. Water rights, stupidest questions ever. Why they test on those? It's like the 2 different doctrines. Make sure you know them. Make sure you know the difference between a lien versus title theory in mortgage. The recording statutes came up quite recently. Those were not tested for a very long time, and just kind of popped their head into the California bar. Couple more. Adverse possession. I said recording statutes, right? Okay. Public and private nuisance. And maybe a few of the future interest rules. That's it. How many is that? 13 categories. So most of them are pure elemental memorization type miscellaneous areas. And then there are some approach. So let's get into where you really need the approach. Landlord tenant. Let's start there. Was real property on my prediction list? Yes or no? Okay, real property was not tested last bar. It was not tested last bar. To clarify, it was tested the one before that. So, definitely on my prediction list. 100% real properties on my prediction list. So far what's been on my prediction list, we've covered contract remedies, which we're going to do another practice in, criminal law, and now real property, and torts, right? Torts, another biggie. So basically everything. Let's begin. So this approach I'm going to play around with. I'm going to simplify like I do with all my approaches. What do you really need to know? Well, you're on the lookout for Statute of Frauds, okay? Because if the lease is one that needs to be in writing, then you want to talk about that. So you may start with a heading Statute of Frauds. just basically establish whether or not the actual agreement needs to be in writing. And then go right into the type of tenancy that you have. Identify the type of tenancy that you have. You may have a tenancy for years, so you may rent an apartment for 2 years. That's a tenancy for years. What is a periodic tenancy? A tenancy that continues for successive intervals until one party gives notice of its termination, something like a month to month, which usually requires how many days notice to terminate? 30 days. So you want to identify the type of tenancy that you have. Now, if your lease has expired and you don't leave, you become what's called a holdover tenant. So you may get a call that asks you, what is the landlord's rights for towards a holdover, right? You may get that, so you need to know that rule. Page 310 gives you the definition at the bottom of what a holdover tenant is. If you turn the page, you see remedies for a holdover. The landlord can evict or bind the tenant to a new periodic tenancy. But if it's only a few short hours of holding over, or if there is a seasonal lease, or if it's not the tenant's fault, there may be an exception. So it's relative to the facts. I mean, if your lease ends September 1st and it's September 1st and you're still moving some of your stuff out, you're not a holdover, right? So we're looking for some period of time where you're not leaving, or some language that you're not actually leaving the premises. And thereby, you can give what the landlord's remedies are. And just so you know, contracts, just like real property for the most part, especially the landlord tenant area, you are going to have to play around with this. Not every single thing here is going to be relevant. So I'm giving you a framework by which to work with, but it's not a solid negligence checklist, right? It's not a solid, it's not very elemental, so it's more conceptual, all right, of what comes up here. So you know the basic concepts and you put down what's at issue. So what usually happens here? Usually you have a landlord, well, you always have a landlord, and the landlord leases to, let's say, tenant 1, who possibly doesn't pay rent at some given point, or assigns their right to tenant 2, or maybe there's a tenant 3. So the first thing you should do on a landlord-tenant essay is map out any relationships that you have. You need to map it out just like this. You may have a landlord 2, an L2, or LL. And dates, maybe L to T1, September 1, 1st. So put any dates in there as well when you're doing your practice. So first be on the lookout for statute of frauds, then identify the type of tenancy that you have. And then you want to consider, do I have any assignment or delegation that has occurred? Maybe there's a non-assignment provision, because what you're trying to do here is you're trying to identify at the end of the tenant, based on the tenancy and based on any succession, okay, that occurred from L1 to T1, from T1 to T2, who has a duty to do what? At the end of the day, who holds the duty to pay rent? I know I'm moving around a lot, Sherry, sorry. It's like here, there, flying. Who has the duty to pay rent is really what it comes down to 99% of the time, all right? So if there's an assignment, that may change the scheme of the relationship, right? So you have to make sure you're first identifying that it was a valid assignment if there is one, or valid delegation. And when you do so basically what you do is you give the law if there is one, and then you establish the privity between the parties. So I'm going to email what I'm about to read. I sent it out last course. I think it's pretty helpful because there's a lot of confusion with privity. So this is what I'm reading to you. Do I want to read this whole thing right now? Actually, no, I'm not going to read it. I'm going to send out an email that goes into a whole description on privity. okay? You're going to sit with it. You're going to make sure that you understand the difference between privity of estate and privity of contract. And you're going to make sure that you understand when that relationship still applies. That's literally a 30, 40-minute hour lecture. I'm not going to give it tonight, but I'm going to email this out to everyone. Make sure that you are able to know when T1 assigns to T2, do they remain in privity of contract and in privity of estate, right? Does everyone know the difference between privity of contract? What's privity of contract?
You have a relationship with the person that you rent to from.
Right, so if you assign to T2, do you have to pay rent, T2? And the assignment is valid. Does T2 have to pay rent? Okay, let me read it. Let's go. It says, here we go. The original tenant and the landlord, okay? Fine, I'll map it out. Fine. The original tenant and the landlord, they start out with what? Good. Privity of estate, POE, and privity of contract. That's what they start out with. However, once a valid assignment occurs, the original tenant, let's do it like this, L to T. Okay? Once a valid assignment, you assign all your right? Your entire right to the property. The original tenant, right here, no longer has privity of estate with the landlord and cannot occupy the premises any longer. I'm going to email this to you, so if you want to write it down, fine, but I think just try and digest it. So once there's an assignment to T1, the privity of estate between L and T, the original L and T, goes away, right? And we're left with only privity of estate, we're left with privity of contract between L1 and T1. Actually, this would be T2. Now what happens? In a real estate context, what is privity of estate? It is the legal relationship between parties whose estates constitute one estate in law. Privity of estate exists when two or more parties hold an interest in the same real property. Clear? Two or more parties hold the same interest in the same real property. In a leasing context, a lease agreement is both a conveyance of interest in a real property and a contract, right? You have the interest in the actual property that you're leasing and the contract, right? The lease agreement. So that's the estate would be the actual estate. Think of it like the where you're living, okay? The apartment you're living in, the house you're living in. And the contract is the lease that you have. If the tenant assigns its interest in the lease to an assignee, and then the assignee assumes the tenant's obligations under the lease, as of the effective date of the assignment, this is what happens. The original, this is why it's so, see, reading it is just, it's going to confuse you, but it's fine. I'm going to email it. You're going to sit with it. The original tenant, so if there's an assignment, T1 right here, no longer has privity of estate with the landlord, we already said that, and remains liable, this is the issue, for the tenant's obligations under the lease. Everyone agree with that? Good. Sorry. Unless the landlord expressly releases the original tenant, or there are state or local laws that establish the tenant's privity of contract terminated. Well, in the case, so we're not going to have that issue. The assignee and the landlord, so T2, this person, what kind of relationship do you think they have? Good. The assignee and the landlord will have privity of estate and privity of contract. They will have both as of the effective date of the assignment and the assumption of the lease. So think of it as if T2 literally steps into the shoes of T1. So T2, if there's a valid assignment, will have the same privity as T1 did at the time of his or her contracting with the landlord. Everyone clear on that? If you're not, you need to really make sure you get clear on it and sit with it and do that. Okay. Now, what about a sublease? And I wrote delegation. I'm not in contracts. Thanks for pointing that out or just laughing at me. Thanks a lot. Yep. I'm still in contract law. Okay. If, however, the tenant subleases all or a portion of its leased premises to a subtenant, then as of the effective date of the sublease. So this, okay, let's just reiterate this. Everyone look up. Landlord 1 and tenant 1 are in both what? Privity of contract and privity of estate. What's the main difference between privity of contract and privity of estate? Privity of contract is in reference to the lease agreement, and privity of estate is your rights on the property. Okay? So at the time that you are the actual tenant, and you've assigned either the original tenant or you've been fully assigned the right? You are one with the landlord in a sense in terms of the property. That's why the landlord doesn't have keys, right? Or they do have keys, but they can't just, commit self-help and go in, right? Because you both, in a sense, even though you're not an owner of the property, you're leasing it, you still have a hold on the property by essence of your lease agreement, okay? So you still have rights to that property, even though you're not the actual owner of it. So that's where the privity of estate comes in. That's why you can put fixtures, and you can make some modifications and stuff like that, even though you don't own the property. All right, so the original tenant and landlord have both forms of privity. Once there is a valid assignment, T1, well, I'm just talking about the assignment for now, T1 will no longer have what form of privity? T1 will no longer, everyone agree with that? Good. So no longer have privity of estate because think of it like this, they're leaving the property. But you're still bound. Once you enter into a contract, the contract it can expire, but if you're just assigning your right, think about it logically. What if there was no more privity of contract with that original tenant, right? And then tenant 2 doesn't pay rent. Is that fair? Now who's the landlord going to go after? There has to remain privity of contract. It protects the landlord, okay? It also protects the tenant because the initial tenant, because the landlord's probably going to come after them as well. All right? So once that happens, that privity of estate is destroyed once the assignment occurs, and the original tenant will only remain in privity of contract. Tenant 2, however, will now take the shoes of tenant 1 and come within what? Privity of estate and contract with the landlord. Everyone agree? Good. What about a sublease? The tenant subleases all or a portion of its leased premises to a subtenant, then as of the effective date of the sublease, let's map this out. The original tenant, and we have landlord and tenant. Okay. Remains in privity of estate and contract, both of them, after a sublease. Okay, this is post-sublease. Well, yeah, if I go and I sublease this room to another attorney, I'm still going to remain in privity of contract and estate. I'm not giving up my entire right to the office, right? So I'm still going to remain in privity of contract and estate with the landlord upstairs. So that's the first scenario. Now, what about the subtenant? What relationship does the subtenant have with the landlord? Actually, the subtenant does not have either privity of estate or privity of contract with the landlord. Has no privity of estate or privity of contract with the landlord. Okay? However, the subtenant has both privity of estate and privity of contract with whom? Yeah, right. Basically, from me. I'm the landlord now. Okay? Any questions on that? Whose head hurts? My head always hurt during this time of lecture when class, Purvi. Okay, so that you have to know this. And why do you have to know this? Because when you're mapping this out, you need to be able to know who the landlord can go after, right? Who can the landlord go after? So that's why I'm having you set that up at the beginning. Set it up at the beginning, set up the relationships, and establish the levels of privity between the parties so you can go right into what now the tenant that has, and you're looking at, usually the question will ask you something along the lines of, is a certain tenant liable for rent, right? Or something along those degrees, or can the landlord go after tenant 1 for failure to pay rent? Something like that. And if so, what remedies could the landlord also have against tenant 1? So maybe they're asking in the question about tenant 2, and they also want to know what about tenant 1. That's where that privity relationship comes in. Okay? You'll see this when you do the practice. It's really straightforward. Tenant's duties. Tenant has a major duty to pay rent, obviously. Pay your rent. What is the tenant's duty to a third party? So this is where you go next. You see if the tenant has paid rent, make a heading, establish that duty. Page 311. You can give the landlord's remedies for the failure to pay rent. So the tenant must keep the premises in reasonably good repair, right? It's pretty straightforward. Who here has ever leased something? Right? Oh, okay. Nobody? No one's ever leased anything? An apartment? No one here has ever leased an apartment? You live in LA? Do you all own property here? Oh, as a landlord. No, I mean like, are you in a lease? Okay. You know, we're all like with our vacation homes here, leasing out our property. Fixtures is a major issue. Isn't this so boring? I know, real property, by the way, such a boring subject. Okay, we'll get through it. Fixtures, they become part of the real property. The issue would be, can the fixture be removed? You have to know the specific fixture rules. It's really, really simple, real property. I promise you, it's so easy, so much easier than any subject on the bar. It's literally not a racehorse. Every single call has a maximum, of 10 or less issues. It's really simple and straightforward. So all you're doing is, usually fixtures will be a specific question, like question 3. What happens to the fixture? Can it be removed? That's it. And you'll have to know the specific fixture rule, okay? So it's not hard. But when you're going towards liability of the duty to pay rent, if there was no payment of rent, your next question is, has the landlord breached? Basically, what are these landlord's duties? Are these the tenant's defenses to not paying rent? So you establish that the tenant hasn't paid rent, and then you consider, well, has the landlord lived up to his or her duty? And basically, these could be justifications, because the question's asking you, does tenant 2 have to pay rent? Or tenant 1 have to pay rent? Can the landlord go after him or her? Well, yeah, they didn't pay their rent. Okay, but the landlord didn't fix the hot water issue for 3 months, and the tenant was living without hot water, and therefore has a breach of the implied warranty of habitability. You make a heading, implied warranty of habitability, and you say that the landlord didn't fix the hot water, and therefore the tenant had no basic remedy other than to leave and go rent a hotel. Something like that. So these are actually the tenant's defenses for the failure to pay rent. So list all of them in a landlord-tenant essay. Implied warranty of habitability will always be at issue, always. The covenant of quiet enjoyment will also always be at issue. Excuse me, list 2 of them, these 2. These are sub-issues. I mean, obviously, the landlord has a duty to deliver possession. If the landlord hasn't delivered possession, then why would the tenant ever have a duty to pay rent? Retaliatory eviction is typically a specific call, and they're only asking as to facts. What is retaliatory eviction?
Change laws, figure stuff out.
No, but what is it? What does the concept support? But what is it? Why is the landlord evicting? Think of the heading. In retaliation for what? Reporting him to something. What do you think? We all rent. What would we report our landlord to? Housing code violation, right? Or some type of public agency. So a landlord cannot evict the tenant for reporting the landlord for a housing code violation. So that's just a sub-issue that you have to know. This is what comes up with landlord tenant. Where does it get confusing? It gets confusing when you have multiple assignments or multiple subleases. So the mapping out of the party relationships, and we're going to do it in class practice next class of this, is the key. But you'll see when we do it, it's really not very complex. Okay, any questions on this approach? Good.